What if I told you that the person you're planning to put in charge of your kid's inheritance could end up getting sued by your own children? And it happens more often than you think. Hi, I'm Chuck Roulet. I'm an estate and elder law planning attorney licensed to practice in both Florida and Minnesota. And over the last 30 years, I've seen this same mistake destroy families over and over again. So today I'm going to show you why naming your brother, sister, best friend, or even one of your adult children as the trustee for your adult kids might be one of the worst decisions you ever make when it comes to your estate plan. So let me tell you why this matters so much to me. In my 3 decades of practice, I've been interviewed by national media outlets such as USA Today, the Epic Times, Live Life Large, and others. And I do continuing education all over the globe for other attorneys and financial professionals. And I've seen what works and what doesn't. And what I'm about to share with you could save your family from years of conflict and thousands of dollars in legal fees. Now, before we begin, if you haven't already, click the like and subscribe button so you'll be notified when I post new videos like this one. Do you have a question? Well, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. Now, to be clear, I'm not saying you should never name a friend, family member, or one of your children as your successor trustee. In fact, they're actually a good choice, maybe even the best choice when you have minor children and you want somebody to manage the money for them until they reach a certain age. If you have a special needs child or beneficiary and you want to put a friend or family member in charge of that. When the trust is designed to terminate and distribute all of the assets when your children reach a certain age, like say 25 or 30. Or when the trustee is only managing the trust temporarily to wrap up affairs and to distribute the assets outright, or when your child is capable of acting as trustee of their own trust and you're establishing it for their benefit. However, if you're leaving assets in an ongoing trust for one or more of your adult children, which is a really great choice if you want to protect their inheritance for them in the event they get divorced, they get sued, want to keep it out of their estate for estate tax purposes or other reasons. And I've actually recorded another video discussing the benefits of ongoing trust for your kids. And I'll provide a link to that in the description below. So if you're doing that and your child is not capable of acting as the trustee of their own trust, then naming a friend, family member, or another one of your kids is a poor choice. And that's what I'm going to discuss with you in this video. So here's what most people don't understand. Being a trustee is like being the family banker who writes checks to your kids. It's actually one of the highest legal responsibilities you can give someone. And when things go wrong, and they often do, your trustee can be personally sued and held liable for every penny they cost your kids. So let me tell you about Robert. His brother James named him as trustee for the 3 kids. When the stock market crashed, Robert panicked and moved everything to cash to protect the money. Sounds smart, right? Wrong. When the market bounced back, the trust missed out on huge gains. James's kids sued Robert personally for hundreds of thousands of dollars in lost returns. Robert, who was just trying to help, thinking he was doing the right thing, ended up losing a significant amount of his retirement savings in legal fees. And unfortunately, this isn't a rare story. You see, when you make someone a trustee, you're asking them to manage investments like a professional, to file complex tax returns every year, to keep detailed records of every penny, to make tough decisions about when to say no to your kids, and to stay completely neutral in family fights. And here's the kicker. They can be personally sued if they mess this up, even by accident. So let me tell you about Martha. She agreed to be trustee for her nieces and nephew because she loved them. But Martha didn't know that trusts need their own tax ID numbers and have to file tax returns every year. 3 years later, when she finally got help, the trust owed tens of thousands of penalties and interest. The kids were furious and Martha felt terrible. But the worst part is it destroyed the relationship. Martha went from being the favorite aunt to someone they blamed for costing them money. And this brings me to the biggest problem of all, what this does to families. So picture this. Your sister is now in charge of your adult son's inheritance. He wants money to start a business, but the trust says funds are only to be used for his health, education, maintenance, and support. Your sister has to say no. So suddenly your son thinks Aunt Susan is being unfair or playing favorites. Family dinners become awkward. People start taking sides. It's a mess. I watched the Johnson family tear itself apart over exactly this situation. What started as a simple no to a distribution request ended with half the family not speaking to the other half. Thanksgiving became a battlefield. Now, your sister didn't ask for this. She just wanted to help. But now she's stuck in the middle of every family drama, and she's legally required to make decisions that might make your kids angry. Let me tell you about Michelle. Her son Mike struggled with mental health issues and had poor money management skills. She named her other son Tom as the trustee for the money she left for Mike. Knowing it was his mom's wishes, Mike accepted the role out of a sense of duty or honor without fully understanding what he was getting into. Not only did the workload of ensuring the money was properly invested and filing tax returns become more than he bargained for, his brother was constantly hounding him for money, which he continually had to say no to as being outside of the terms of the trust. The strain became so bad that he resigned. Unfortunately, even though he did nothing wrong and resigned, Mike still sued Tom, alleging lack of access and mismanagement of his trust funds. Even though Tom eventually resolved the lawsuit in his favor, the legal fees ate up a significant amount of the money Michelle left for Mike and destroyed the relationship between her sons. Surely this was not the legacy Michelle meant to leave. So what's the solution? Well, you might want to consider a professional trustee. Now, I know you may be thinking to yourself, well, Chuck, that sounds expensive and impersonal. But hear me out. Professional trustees do this every day. They know the law, they handle investment properties, they file taxes on time, and most importantly, they don't get emotionally involved. So when they have to say no to your kids, it's business, not personal. Now, the Wilson family made this switch after years of family tension. Their kids told me that distribution requests became less stressful, their returns got better, and family gatherings could actually be about family again and not trust business. Yes, professional trustees charge a fee, usually starting at about 1% per year, although it can be more. But think about what you get: professional investment management, proper tax filings, detailed record keeping, and zero family drama. When you add up the potential costs of mistakes, legal fees, and damaged relationships, it can make sense in the right situations. Now, if you still want family involvement, there's a hybrid approach that may work well. You can have a professional trustee handle the technical stuff, the investment, taxes, and record keeping, while keeping a trusted third party acting as what's known as a trust protector with oversight authority. This may give you the best of both worlds: professional competence with family insight. Now, look, I get it. Choosing a stranger over your brother feels wrong. But remember, your job isn't to honor your brother. Your job is to protect your kids and preserve your family relationships. And sometimes the most loving thing you can do is to take the burden off of your family's shoulders. So if you would like to discover more or to schedule a consultation to discuss your own planning, visit us at roulettelaw.com. I'm also hosting an exclusive masterclass where I'll be revealing the strategies I use with my private clients and their families to help them avoid probate, save on taxes, and protect their children's inheritance from divorce, bankruptcy, and creditor claims. And you can click the link in the description below to join us. This masterclass isn't available anywhere else, and it could save your family years of conflict and thousands of dollars. So don't let a well-intentioned trustee choice destroy your family's relationships and your children's financial future. The right planning today protects both your legacy and your family harmony. I hope you found this video helpful, and I look forward to seeing you in either an upcoming video or the masterclass. Be well.